All right, today we are going to talk about how blame gets split in motorcycle cases and how to fight back. Welcome to our new informative segment of Moto Talks with Mitch and Mel from the law firm of Proner and Proner. I'm your host and fellow writer, Mel McCuyab. And as often as we can, we will sit down with the personal injury expert himself and writer, Mr. Mitch Proner, a personal injury attorney with over 30 years of experience here to answer your questions or any interesting topics that you might find useful in the personal injury world. And remember, folks, if you need to contact us, all consultations are free and confidential. Give us a call at any time at 1-800-321-1234. All right, Mitch. So how are you doing, Mitch?
Doing pretty well. It's a great topic because, all right, so I have, not only am I a rider, I had my own motorcycle accident case where I broke my wrist, my ankle, and 7 bones in my back in the 90s. And I still ride. But over the years, I have settled cases. I've arbitrated cases, motorcycle accident cases. I have settled motorcycle accident cases. I've arbitrated motorcycle accident cases. I've mediated motorcycle accident cases. I've tried motorcycle accident cases in different jurisdictions.
Right.
I've handled motorcycle versus car, motorcycle versus truck, motorcycle versus bus, motorcycle versus motorcycle, motorcycle versus roadway defect, motorcycle versus sign defect. And so, how does liability get split? That's how fault gets divided. Liability is equal to fault. Words are interchangeable. Who is liable? Who's at fault? Okay. That's different than damages. Damages are, what are the injuries? I spoke to a client yesterday on a case, and he was not at fault for the incident, but he wasn't really injured, and he wanted to get a big recovery, financial money. And I was talking about why his case isn't a $1 million case. And he said, it's like they're penalizing me because I wasn't badly injured. And that's not it. It's a personal injury lawsuit. It's not a personal angry lawsuit. It's a personal injury lawsuit. You have to have injuries to get compensation because there's 2 parts. One is who's at fault. And that's not by my opinion. That's by the law. When you try a case, the jury, first, if it's tried before a jury, you can try a case before a judge too. But if you try a case before a judge or a jury, the first determination is who's at fault, and then what are the damages. Now, if you prove the other side is 100% at fault, but you don't have any damages, you don't get money. But they're at fault. Yeah, but you weren't injured. You don't get money. Now, let's suppose the jury decides, or the judge decides, if you try it before a judge, that it's 50-50.
Okay.
Well, if the damages are determined to be by the jury $100,000 and fault is 50-50, then you get $50,000. You don't get $100,000 because it's half your fault. But if you prove the other side's 100% at fault and the damages are 0, you get half of 0. It's still 0. You still need to have injuries to get compensation. You can't get compensation on fault alone. So how's fault divided? The first place it's divided, typically, is the cop shows up. And he looks around and he says, what happened? And the cop might determine who's at fault. Well, it looks like this vehicle switched lanes without signaling. I'm going to put them at fault. Guess what? If the case goes to trial, typically the cop's determination at the scene is not admissible. His ultimate opinion on fault or division of fault is not admissible.
Okay.
There's a case, Weiss v. Fote, which says doesn't come in. Now, you could lay a foundation if the cop's been trained in accident reconstruction and in fact does an accident reconstruction, takes measurements and does the mathematics, but they're not doing that at the accident scene unless it's a fatality or they think it's a near fatality, and it might be, then they might bring in their accident reconstruction team. And then their determinations might be admissible. But the typical report that you see after an accident, it's not admissible. But the insurance carriers, they're the second ones that are going to determine fault. And they typically will do it, number one, based on the police report. We're not going to pay because the police report says you're at fault.
Okay.
They do. They look at the police report. Even though the police report's not admissible, they can still say, yeah, well, based on the police report, we're not paying. Now, let's suppose the police report's in your favor. The insurance carrier can hire an investigator. This happened to me just last month. Accident happened, and client said he was following his buddy who was ahead of him, and they're going through an intersection, and a car crashed into them. Well, who had the green light? When we entered into the intersection, it was green. Okay. The insurance carrier sent an investigator to the houses around the intersection, found a house with a doorbell camera, and based on the doorbell camera, it shows my client going through a steady red light.
Oh, wow.
And I called up my client and I said, it looks like you went through a steady red light. And my client says, I know. That's why I got a lawyer right away.
Oh, my God.
And I said, okay. Doesn't mean I could get you money.
Yeah.
They're not going to pay. And I'm not going to want to take the case and go to trial.
Yeah.
When it shows you going through a steady red light. And he said, all right. They want to take a statement from me. Should I give them a statement? I said, it doesn't make a difference. They're not going to pay you. Anyway.
Oh, man.
So the carrier, the insurance carrier, they're the second ones that are going to determine fault. And typically they're going to determine fault against you. Now, a lawyer in your favor doesn't have to accept their idea of who's at fault.
Okay.
For example, a typical left turn case. They might say, well, yeah, our vehicle made a left turn, but your client was going too fast.
Yeah.
So we think it's 70-30. And we're only going to pay 70% on the property damage. Now, the client might say, look, I'll take 70% on the property damage. I just need to get something. I got to get a new vehicle. I don't have collision on my own bike. They might accept that. It's up to the client. But if the case on the personal injuries goes to trial, I don't have to accept that 70-30 split. As a matter of fact, I established with my firm's appellate work, appellate law, which is the highest law, where I've had clients get 100% as a matter of law. You didn't even have to try who's at fault on a left turn case. But the carrier is not going to necessarily agree with that unless I take depositions and present evidence, and I could win 100%, given the right set of circumstances on a left turn case. I established that law in New York. But, and as a matter of fact, if the lawyers look up the law in New York on motorcycle accident cases, typically they're all my cases that are being cited.
That's awesome.
Because we made law on motorcycle accident cases in New York. That being said, so first off, it can be determined by the police officer. Second, by the adjuster. Third, by a judge. on a motion for summary judgment. And lastly, if a case goes to trial, it's determined by a jury. And they can apportion liability. Apportioning liability means dividing up 60-40, 30-70, 80-20, but it has to add up to 100.
Okay.
And that can affect how much money you can recover based upon the more the other vehicle's at fault, the more you're entitled to be compensated. In New York, even if you're partially at fault, you're still entitled to compensation. In other states, it's a modified comparative. We have to show the other side's more than 50% at fault. In other states, it's pure contributory, which means that even if you're a little bit at fault, you're not entitled to any compensation.
Mm-hmm.
That's strict contributory liability. New York is comparative liability, where even if there's a division of fault, you're still entitled to compensation. So that's how fault gets apportioned in New York.
Okay. So, one of the questions here, and if you can just clarify this, maybe it's basically what you said, but comparative negligence, can you expand on that? Or is that just another way of
Sure.
phrasing
Okay.
what you said?
So negligence is typically the failure to act reasonably under the circumstances. What would a reasonable person do? A reasonable person will stop for a red light.
Mm-hmm.
Now, if you violate a vehicle and traffic law or ordinance, that's evidence of negligence, meaning that's evidence that you didn't act reasonably. Now, it's possible that both sides are negligent or didn't act reasonably. For example, a car might run a stop sign,
Right,
but I might be going 100 miles an hour through a school zone, which should be a lower speed limit than 100 miles an hour.
right.
So let's suppose the speed limit there is 25 miles per hour, and I'm doing 100. Well, I violated a vehicle and traffic law, and the other vehicle violated the vehicle and traffic law by not stopping at a stop sign. So both sides could be at fault. But negligence is what you need to prove to be compensated. Negligence is the same thing as proving the other side's at fault. If they're at fault for being negligent. So comparative negligence means me and the other party, right? Two parties to a lawsuit. The plaintiff sues the defendant. The plaintiff brings the complaint. The defendant answers the complaint. In order for the plaintiff to get money from the defendant, the plaintiff has to prove that the defendant was negligent. Then, if you prove the defendant was negligent, the plaintiff still has to suffer damages for the defendant to have to pay the plaintiff money.
Yeah. Okay. That definitely clears it up for me. Thank you, Mitch. Well, there you have it, folks. I mean, yet another great information from Mr. Mitch Proner. Thank you, Mitch. And don't forget, if you need our help, give us a call 24/7 at 1-800-321-1234, where consultations are free and confidential. That'll do it for now. And thanks again for taking the time to tune in, whether it's on our podcast, video broadcast, or we really do appreciate you taking the time to tune in. And please, if you haven't yet, follow us on Instagram, TikTok, Facebook, and of course, YouTube. Like, share, and please subscribe so you get the latest updates. Now, before we go, Mitch, do you have anything else you want to add?
Yeah. when it comes to negligence, you don't have to admit your own negligence. There's no part of the law that requires that. If a police officer asks you how this accident happened, talk about what the other vehicle did wrong. You don't need to tell on yourself. You're not required to. And if an insurance carrier calls you up and wants to take a statement, you shouldn't be doing that without being prepared by a lawyer. Because a lawyer can explain the law under your particular circumstances, which might influence the statement you give to the insurance carrier. Doesn't mean I have to tell a client to lie. I would never do that. That's not ethical. But I'm entitled to tell the client the law before they give any statement. And no smart individual is giving sworn statements without speaking to an attorney beforehand if the matter that they're speaking about may potentially involve whether or not they receive substantial money or not. And when somebody typically brings a lawsuit, they're looking to get substantial compensation for the injuries they've sustained.
Right.
So the consult is always free, and it's a good idea to consult with an attorney that's experienced.
Well, there you go. Thank you again, Mitch, for yet another informative session with you. And thank you all for checking us out. And remember, we ride just like you. We'll see you next time.
That's
See you,
true.
Mitch. Thank you.
Thanks, Mel. Be well.
You too.